Good evening. Welcome to everyone, especially to our guests this evening. We're coming out from South Africa, Johannesburg, as the Palestine Solidarity Alliance, an organization that's been active in the solidarity movement since the World Conference Against Racism, Durban 1 in 2001. But most of our members are actually activists from the struggle against apartheid and have been active in the human rights movement for all of our lives, if you like. We are doing a number of different things. One of that is the legal actions or the lawfare that the PSA together with the MRN initiated for the Gaza docket, and I'm glad to see that Yusha is one of the panelists today, and we're good to work with him on that. Other stuff that we're doing relate to boycotts, divestments, and sanctions, mobilizing and lobbying our own government, faith-based communities, and other people and organizations around the country to support the boycotts, divestments, and sanctions movement. So the PSA is one of the many PSOs in the country, and the good news is that recently we've been able to establish a coalition, or the South African Boycotts, Divestments, and Sanctions Coalition, and we look forward to this organization taking us forward and making a real impact in the struggle for the liberation of Palestine, and for an end to the Israeli apartheid state of colonialism, Zionist state of colonialism and occupation. We meet at difficult times with the threat of a annexation in July, but we know that de facto, a little bit of law that I have, is on the ground that people are being evacuated, people are being forcibly removed from their homes, people are being forced off their farmlands, and that the annexation and the settlement project has been ongoing for some time. And much of those forced removals, these evictions, mirror the history of our own country, and we are very, very concerned about that. But tonight we are very happy to have with us a number of legal experts. I'd like to just thank Burak Turan, Hakan Kamuz, Ziad Patel, Yusha Tayob, Catherine Gallagher, and then obviously Zinat, our moderator for this evening, for making this program possible. Zinat is an independent international relations strategist, an entrepreneur, political opinion writer. She has worked in the Department of International Relations, headed a mission for the South African Embassy in Qatar, serving as one of the youngest counselors at the time. She's quite dynamic, and she will guide us through the program today, drawing on from her own expertise in the diplomatic circles, but also, most importantly, Zinat is one of those activists that the PSA are very glad to have worked with. She, together with the other lady behind the scene, Shabnam, who were our representatives on the women's boat to Gaza and part of the Freedom Flotilla initiative. So today we're very, very glad as the PSA to join in another event with the FFC, and we look forward to the inputs and responses of all our esteemed panelists this evening. So over to you, Zinat, and good luck to everyone. Thank you.
Bismillah ar-Rahman ar-Rahim, and salam and good evening to everyone joining us. Thank you to Nazim for the introduction. I am honored to moderate this webinar, and I'm sure we'll have a robust and insightful discussion. Welcome to this webinar on the national and international legal actions against the Israeli occupation from the Gaza Freedom Flotilla to annexation, hosted by South Africa's Palestine Solidarity Alliance. As we commemorate 72 years of the Nakba and concurrently witness the drastic shift in international acceptance of the flagrant violations of international law, United Nations resolutions, and advancements towards annexation of the West Bank, we need to challenge these actions utilizing the international mechanisms available at our disposal. This month is the 10th anniversary of the Israeli military attack on a flotilla of 6 boats that were sailing towards Gaza in May 2010 to bring international attention to the plight of the 2 million Palestinians living under inhumane land, sea, and air blockade. The boats were accompanied by 3 cargo shiploads of humanitarian assistance. Israeli commandos belligerently boarded the vessels with absolute disregard for human life, killing 10 passengers, wounding more than 50 unarmed civilians on the Mavi Marmara ship. Passengers on the other vessels were viciously attacked, causing undue trauma. This webinar series commemorates those killed in the 2010 flotilla and the Palestinians in Gaza, the West Bank, and Israel who have been massacred by the Israeli military. And it seeks to highlight the inhumane policies of the Israeli apartheid government. Since 2008, the international solidarity activists have sailed 18 voyages with over 30 boats in an effort to break the Israeli blockade. The next flotilla has been postponed from May 2020. It is coordinated by the Gaza Freedom Flotilla Coalition, which is sponsoring this webinar series. Tonight, I am joined by remarkable minds from across the world who have sought to employ international legal mechanisms in opposition to the brutal occupation of Palestine. These methods of solidarity and resistance not only expose the Zionist occupiers' fallacious discriminatory practices, but also offer sophisticated juridical means of resistance and solidarity beyond placard protests. We have in our midst Burak Turan, who is a member of the Istanbul Bar Association. He is a partner of YILDIRIM Law Firm established in Istanbul and a lawyer of IHH-Humaniterian Relief Foundation. He is also a member of Mavi Marmara Law Commission in Turkey. Burak followed the process of preparing an indictment against Israeli commanders at the Istanbul prosecutor's office. He followed closely the hearings of the case in which decisions were taken to issue arrest warrants originating from Interpol in the Istanbul High Criminal Court. He filed lawsuits on behalf of the victims against Israel in the Turkish civil courts and has made applications demanding the cancellation of the agreement between the Republic of Turkey and Israel. He appealed to the Supreme Court for the annulment of the decision to drop the criminal case. We are also joined by Hakan Shamuz. He is the head of international law at Stoke White Law Firm, which has led on several cases against Israeli war crimes, including the case of the Mavi Marmara Flotilla, on behalf of the government of the Comores, a flag nation of the Mavi Marmara, as well as individual victims. Hakan has more than 20 years legal experience dealing with international cases on behalf of governments, NGOs, and individuals. Hakan has successfully led many highly trained lawyers in various international cases and special matters, including international sanctions, international criminal law, and international arbitration cases. He has also specialized in strategy and policy development for clients. Hakan has been central in establishing the structure of several charities based in the UK and continues to contribute to humanitarian organizations around the world. He holds a BA Honours degree in Politics and International Relations and has a Master's degree in War Studies from the King's College London. We're joined by Ziad Patel, who is a South African international human rights lawyer and ardent lawfare activist. He is the attorney of record for the South African victim in the 2010 Mavi Marmara Freedom Flotilla attack and represented former anti-apartheid activist Ronnie Kasrils in his contribution to the Gaza docket on Israel's belligerent crimes against humanity. Ziad represented international organizations Khiam Center for Rehabilitation and Tadamun in advocating Palestinian prisoners and children's rights in 2016 at the United Nations Human Rights Council. He is also the drafter of the first citizens' bill of its kind, South Africa's Implementation and Protection of Palestinian Solidarity Rights Act, the IPSRA bill. Ziad is a member of the Palestine Solidarity Alliance and was the legal advisor for the South African delegate to the Women's Boat to Gaza. Yusha Tayyib is a South African attorney who has been practicing since 1994. He was the attorney of record for the Palestine Solidarity Alliance and Media Review Network for the Gaza docket, a case which seeks to bring the South African soldiers who served in the Israeli Defense Force to justice for their role in the Gaza war. Yusha is a founding member of the Muslim Lawyers Association, which has brought various cases under the Rome Statute for human rights violations in Palestine, Egypt, the Ogaden, Kashmir, to name a few. Catherine Gallagher is a senior staff attorney at the Center for Constitutional Rights. Excuse me. She works on universal jurisdiction and international criminal law cases involving the United States and foreign officials and torture and other war crimes and civil actions involving private military corporations and torture at Abu Ghraib. Before the Center for Constitutional Rights, she worked at the United Nations International Criminal Tribunal for the former Yugoslavia from 2001 to 2006 as a legal advisor for the Organization for Security and Cooperation in Europe in Kosovo and with the Special Court for Sierra Leone in Freetown. She graduated from New York University with a joint MA in journalism and Middle East Studies, and from the CUNY School of Law, where she served as editor-in-chief of the New York City Law Review. Her other major cases include situation of Afghanistan at the International Criminal Court, pressing to open a criminal investigation of US torture in Afghanistan and at CIA black sites, Al-Shimari versus KC, brought by Iraqi detainees tortured at Abu Ghraib, and Survivors Network of those abused by priests versus the Vatican, seeking accountability for crimes against humanity of sexual violence by clergy and cover-up. She was a vice president on the international board of the International Federation for Human Rights from 2010 to 2016. She is a member of the editorial committee of the Journal for International Criminal Justice and is a visiting professor of law at the City University of New York School of Law. I will invite our guests to present, and thereafter we will respond to questions. Viewers may submit their questions in the Q&A box on Zoom or through the Facebook link, and we will do our best to address them. I will request that our speakers please keep to their time allocation to allow for an engaging and interactive discussion. As we are commemorating 10 years since the vicious attack on Mavi Marmara, let us begin with Burak. You have followed the cases brought to the courts in Turkey. Would you please explain more about the Mavi Marmara incident and the legal processes that followed?
Thank you. Yes, hello to all participants. As you explained us, we as a Yildirim law firm are the main centers conducting law process in Turkey about Mavi Marmara. As you know, and you said, we are also the lawyer of IHH, Human Rights and Freedom's Humanitarian Relief Foundation. As you know, IHH was one of the leaders of the Gaza Freedom Flotillas organization. So all legal and administrative actions here followed by us. We started to ensure that Israeli civil and military officials who are the perpetrators of all crimes to be tried in a court and punished, announced Israel's persecution to the public world and recorded in the legal literature. I will start to explain you the national criminal jurisdiction process firstly that we followed in Istanbul High Criminal Court. Criminal complaints containing our request for the punishment of the perpetrators were delivered to the Istanbul Chief Public Prosecutor's Office right after the incident. The investigation opened by the Chief Public Prosecutor lasted for 2 years. Indictment filed by the Chief Public Prosecutor after a difficult process. The Chief Public Prosecutor made extensive reviews and research, like taking statements from all victims, taking forensic reports of the martyrs, injured, and all the other humanitarian volunteers. A lawsuit filed before the Istanbul 7th High Criminal Court in May 2012. 78 foreign, a total of 502 complainants took place in the fight. 4 senior commanders of the Israeli army, Israeli Chief of Defense Forces, Gabriel Ashkenazi, Eliezer Marom, Avishai Levi, and Amos Yadlin requested to be punished. The crimes contained in the indictment: attack, order to intentional homicide, attempted intentional homicide, qualified intentional injury, qualified latrocination, hijacking of the sea, railway or airline transportation vehicles, qualified causing damage to property, deprivation of liberty, and torture. The chief prosecutor requested that thousands of years be sentenced for each victim separately. In the criminal case before the Istanbul 7th High Criminal Court, necessary diplomatic and legal procedures were carried out at the official level for Israeli generals to be informed about the case and defend themselves. And at the hearings, testimonies of all foreign and Turkish victims was taken as complainant or witness statute, and evidence were investigated. the testimonies that taken in each hearings were registered to the history. On 22 March 2013, Israel Prime Minister Netanyahu made a phone call with Prime Minister of the Republic of Turkey, Erdogan, and apologized for the Mavi Marmara strike, notified that they were ready to pay compensations. After that, negotiations started between the state of Turkey and the state of Israel in order to make an agreement specifying the amount of the compensation and payment terms. Fleet organizers and all victims of the strike and relatives of the marchers made statements to the press with the different parts contains the issues that they are sensitive in negotiations between the parties. They submitted their demands including, first of all, removal of the inhuman blockade imposed on Gaza, the accountability and punishment of all political and soldiers responsible for the Mavi Marmara strike before the judiciary, and after these, Israel's payments for all material and moral damages that it caused. At the hearing held at the Istanbul 7th High Criminal Court on 26 May 2014, arrest warrants were issued for the perpetrators and the Interpol arrest was issued. In the trial that continued until 2016, compensation procedure agreement between Republic of Turkey and the State of Israel made in 2016 led to a new controversy. At the hearing on 2 December 2016, public prosecutor requested dismissal of the case by virtue of the agreement made between Turkey and Israel. We, as an attorneys of the victims, expressed our objections verbally and in writing. I want to explain our objections in here. Article 4 of the agreement text is legal amnesty, and in this case, that article should be voted and get at least 330 votes from the Grand National Assembly of Turkey. And this agreement, which doesn't pass in this way, is contrary to the constitution in this respect. The agreement regulates the family of 10 martyrs. However, families of martyrs demand the continuation of the trial, the prosecution and punishment of those responsible. All Turkish victims want the trial to continue, and the case cannot be dismissed based on this agreement. And if so, a lawsuit will be filed at the Constitutional Court and the European Court of Human Rights. Turkey and Israel's agreement is not binding for the victims who are not Turkish citizens, and the case cannot be dismissed for the victims from other countries. Objections based on Turkish national law and international law and expert opinions explaining these objections with scientific justifications are presented to the court. But unfortunately, at the hearing held on 9 December 2016, the prosecutor repeated his opinion and request again. Despite all of these objections, the court board made a wrong decision and decided the case to be dismissed. This decision, which is against national and international legislation, was appealed by us as attorneys of the victims. Now the case is still on the appellate review before the Istanbul Regional Court of Justice. We are hoping a positive decision from this High Court and start to continue to this case again. At this pace, also I want to explain the situation of national compensation cases in here that we followed on behalf of the victims. Since all crimes committed in the attack by Israeli soldiers are also unfair acts committed against victims in terms of private law, the state of Israel has responsibility for compensation. For all these reasons, all victims have right to file damages in Turkish laws. Currently, there are lawsuits filed on behalf of 85 victims in Turkey in general, and there are ongoing proceedings. In compensation lawsuits on behalf of the victims, the Treasury of the Republic of Turkey has taken sides with the State of Israel within scope of procedural agreement relating compensation signed between the Republic of Turkey and the State of Israel. Because according to the agreement, Turkey has taken the responsibility of the compensation that State of Israel would have to pay due to the Mavi Marmara attack. With the material and moral compensation decisions given in these cases, the registration of the unfair acts committed in the attack is also ensured. I want to finish my speech with my thoughts about all this process. The legal struggle regarding the Mavi Marmara case is the breakdown of legal immunity Child Israel had created. The Mavi Marmara continues its cruise with the national and international legal and administrative authorities, and its cruise struggles to seek justice and punish Israel for murders committed before the eyes of the world, for torture and torment. These legal and administrative authorities are expected to serve the purpose of establishing justice and international law and act in accordance with their establishment philosophies. Thank you for attention.
Thank you very much, Burak, for keeping to your time and for enlightening us on the case. I think that it is quite challenging, especially when you have an agreement and diplomatic processes between Israel and Turkey that seem to impede the course of justice. It has become a norm for the solidarity movement to draw comparisons of Israeli occupation to the system of apartheid in South Africa. The bonds between South Africans and Palestinians are therefore tightly knit because of the shared experiences that they have. One of the passengers on board the Mavi Marmara when it was attacked was Khadija Davids, a South African journalist. Ziad, you acted on behalf of Khadija, who survived the attack. Please tell us more about your client's experience and the case that followed. I also understand that you've tabled a unique legislative bill, the Implementation and Protection of Palestinian Solidarity Rights Act. Why is this bill so important at this stage for South Africa, and what do you seek to accomplish with it?
Thank you, Zinat, and good evening to my fellow colleagues and comrades in this very important task of championing Palestinian solidarity rights. Most certainly, lawfare is a mechanism by which we can utilize as a means to seek justice for Palestinians that are in a very, very difficult situation at this time. Zinat, I've tried to put my presentation to discuss two issues. The one is Khadija Davids and the case that was brought in South Africa, and also the South African IPSRA bill. Due to time constraints, I don't think I'll be able to keep to my time frame, but I'm going to try as much as possible to try and cover those areas that need to be discussed on this important webinar. So to start off with Khadija Davids, what was important in this case? Two important decisions were made. The first, on the 4th of November, the National Director of Public Prosecutions communicated that jurisdictional requirements were met to open an investigation in terms of South Africa's implementation of the International Criminal Court Act by virtue of South Africa domesticating the Rome Statute. Khadija, being a South African citizen, refuted one of the legal challenges raised in the Gaza docket based on locus standi. This was the first important decision of its kind, where crimes perpetrated outside the territory of the Republic would be investigated within the borders of South Africa. What were the important legal observations in this case? And that's something that we need to focus on. So these important observations are that codified principles of universal jurisdiction, rather than in its customary common law form, can have greater legal efficacy in its implementation thereof. There was the potential for the IDF to be held accountable for its crimes, which were perpetrated extraterritorially against humanitarian aid activists and civilians aboard the Mavi Marmara. The second important decision was communicated on 10 November 2015. Due to certain policy changes and constitutional court decision in National Commission of South African Police Services versus the Southern African Human Rights Litigation Center, powers and functions were judicially framed of investigating and prosecutorial organs of state dealing with investigations in terms of the Implementation Act. Khadija's decision culminated from intensive legal representation made both to the NDPP, Priority Crimes Litigation Unit, and the South African Police Services Director of Priority Crimes Investigation Unit, spanning over a period of 5 years. In these representations, the victims and lawyers of the IHH also met with South African authorities. The decision from the South African Police Services divisions stated, who at the time were indicted, the decision from the South African Police Services listed the 4 IDF commanders who were at the time indicted before the Istanbul High Criminal Court, which our colleague Burak spoke about earlier. As you all know, this was a separate monumental judicial process being undertaken in Turkey, where evidence of the attack by victims aboard the Mavi Marmara and the Flotilla vessels boarded by the IDF Navy commandos. Humanitarian activists from across the globe participated in this groundbreaking judicial process in the preservation of evidence and witness testimony. The Istanbul Criminal High Court had issued warrants of arrest in absentia for the 4 IDF commanders, which was a significant victory in the noble pursuit of justice for victims. Now, what was the important decision? The decision was that the Turkish arrest warrants were translated into English and submitted to the investigating officer in South Africa. The IDF suspects' names were circulated on South African border control. This was also circulated to Interpol Pretoria for their Turkish counterparts to issue a red alert notice. In line with the aforesaid Constitutional Court judgment, South African authorities took pragmatic intervention in coming to the aid of a South African citizen and complying with its international obligations as a signatory to the Rome Statute. If any of the accused IDF war commanders would enter SA territory, they would be arrested and extradited to Turkey to face charges in the indictment before the Turkish criminal justice system and appear before this court. Now, following on our preceding speaker, and who spoke about the ignoble bilateral treaty between Turkey and Israel, I want to underscore that the bilateral treaty signed between Israel and Turkey severely impacted on our case. However, should any of the 4 implicated suspects be found in the territory of South Africa, we shall request that the alleged perpetrators be investigated and prosecuted within the domestic South African criminal justice system. The alternative would also mean a state referral to the International Criminal Court to look at such avenues that would be available to have, and I believe that certain colleagues will be speaking with regard to the International Criminal Court process. The legal instruments in international law, the basis of the Khadija Davids complaint relied on South Africa's ICC Act with IDF's violation of international law, international criminal law, the perpetration of war crimes in international waters that was approximately 84 nautical miles off the coast of Gaza. We relied on the San Remo Manual, law of the seas, and pertinent provisions of the Geneva Conventions with legal responsibilities of the occupier in occupied territories formed the basis of the legal complaint. IDF violations of collective punishment and disproportionate use of force against the people of Gaza breached international humanitarian and human rights law. We also relied on the UN fact-finding mission report into the Flotilla aid attack and the Goldstone report on the Gaza war in 2008-2009, which formed the basis of the complaint. The report on the international fact-finding mission for the Flotilla aid attack concluded that the series of violations of international law, including international humanitarian and human rights law, were committed by the Israeli forces during the interception of the flotilla and during the detention of passengers in Israel prior to deportation. Paragraph 58 of that same report emphasized that no case can be made for the legality of the interception and the mission, therefore finds that the interception was illegal. The mission finds that the policy of blockade or closure regime, including the naval blockade imposed by Israel on Gaza, was inflicting disproportionate civil damage. This is an important aspect because we could see that utilization of South Africa's implementation of the International Criminal Court Act had brought some kind of a favorable decision by relying on South African law. And based on that and certain experiences over the last decade being involved initially in the first Gaza docket, which my fellow colleague will be speaking about, then looking at the Khadija Davids complaint, where certain organizations like the Muslim Lawyers Association, Media Review Network, and the Palestine Solidarity Alliance played a critical role and a crucial role in coming to the aid of Khadija Davids and representing the complainant and assisting in that part. But we needed to look at what kind of avenues can be available in dealing with Israeli war crimes and the perpetration of crimes committed with absolute impunity. I'm going to share a screen, Zenith, which is a presentation that I've prepared on IPSRA, I just want to briefly go through some of the important policy tools and the legislative framework, because that's important in interweaving, utilizing current South African legislation, as well as South Africa's domestication of the Rome Statute, the international conventions that they've signed, and strengthening that by proper legislation to hold Israeli war criminals accountable for what had happened on the Flotilla aid attack, or for instance, the continued crimes of settler colonialism and apartheid. We know that annexation is also on the cards. That's a serious issue for Palestinians. It has the critical, Palestinians at the critical juncture. And we know that there's the intractability of international institutions, whether that would be at the United Nations or even at the International Criminal Court. So as a lawfare activist, I focus on the principles of complementarity, whereby we can utilize international law, but at the same time also see how we are able to strengthen our own national domestic jurisdictions and have that as a model for other states to build on. Because what happens is, if we have many countries starting to participate in this advocacy process of legislation, we then, start dealing with, the Israeli war crimes and the perpetration of apartheid, and making apartheid Israel accountable for its crimes. I'm going to share a screen. I just want to get to that presentation. Okay. Does everybody see that screen? Seen it?
Yes, we are able to see that. I am going to give you a time, Ziad. You've got 3 more minutes.
Okay, great. Thank you, Zinat. Okay, so what is IPSRA? What is IPSRA? IPSRA policy, it's Impactful Lawfare Initiative. It's there to create domestic legislative and regulatory framework. It's the development of international intifada of resistance through peaceful means. And why? As I've said, because of bias and intractable international institutions like the UN and the ICC in enforcement of international law against the apartheid state of Israel. In the IPSRA preamble, we have its responsibility, South Africa's responsibility, and South Africa being having experienced apartheid, being at the champion of the Palestinian cause because of our historical geopolitical context. IPSRA means for South Africa meeting its international obligations, and of course, because we are signatory to the Rome Statute. And most importantly, it's there to convert the political rhetoric holding the South African government accountable in upholding international obligations. What is IPSRA? It's a Future Solidarity Rights Act. It's the first of its kind. It's the conversion of political rhetoric and posturing into a constructive legal and regulatory framework. Very important is the establishment of a boycott, trade divestment, economic sanctions, and lawfare council. And this would deal with a institutionalized approach in the way we address apartheid Israel on government-to-government level. Carrying on with that, just to the next slide. Of course, this is because South Africa is a party to the Rome Statute, and we know of Israelis stifling blockades, belligerent occupation, and continued breaches of international law. I just want to say, how will this be undertaken? We have domestic laws like the Criminal Procedure Act, Universal Jurisdiction. We've got the regulation of Foreign Military Assistance Act. I am involved in the current case there, representing a South African citizen. We know that South African Jews go and serve in the IDF, and that's a breach of South Africa's constitutional obligations. What's the scope of the council? It will be constituted by the Minister of Trade and Industry, and it would work across sectors. Most importantly, the Lawfare Council will be there to advise government on the most efficient means of divesting from apartheid Israel. What are the alternatives? What are the economic alternatives if we had to go with that approach? Just almost completed. We know Magdalena Mughrabi, Deputy Regional Director at Amnesty International, said that, US is a major buyer of Israeli military equipment, but that includes the European Union nations, including France, Germany, the UK, and Italy. And IPSRA is a means of stopping that kind of military trade and making sure that the IDF does not get supplied for its next war. The IFSA would have specialized courts, including the High Court. Also, what's important, I think, from the area that we wanting to look at, creating some kind of offenses and penalties so that if South African companies are involved, there would be stringent penalties in place for corporations, multinational companies that trade within South Africa with apartheid Israel, and that if there's contravention of the IPSRA Act, once it's passed at that stage, that there will be certain penalties, meaning that there would have to be behavioral change, both on economic and personal level. Why do we need to do that? This is important. We need to do this because this is how we won the apartheid struggle in South Africa. I see Palestinians at a stage where South Africa was during the anti-apartheid movement, when we were in exile, in isolation. Anti-apartheid veteran Oliver Tambo indicated or made some very important contributions to the anti-apartheid movement. And I just want to say, I mean, one of the important quotes is the fight for freedom must go on until it is won. Until our country is free and happy and peaceful as part of the community of man, we cannot rest. And also, we believe the world too can destroy apartheid, firstly by striking at the economy of South Africa. Our watchword must be mobilization, organization, struggle. All our people must be mobilized into action. All our people must be organized for action. All our people must engage in struggle. That must be our reply to the enemy's desperate counteroffensive. And this is what I'm saying, is that from a lawfare perspective, we need to be able to do proper, impactful advocacy in strengthening the Palestinian cause, especially at the time of the annexation. Zinit, I will leave it there and contribute later in the discussion. Thank you so much.
Thank you very much, Ziad, for the insightful presentation. We have had some requests for you to share this presentation with some of our viewers. For those who have requested that, we will try to make it available on the Freedom Flotilla Coalition website, as well as on the PSA website, if Ziad would be so kind as to share that with us.
That would be a pleasure. Thank you.
I would now like to invite Hakan, who also worked on the Mavi Marmara case, representing the government of Comoros. Hakan, in this case, I understand that you have been deeply involved in challenging the inner workings of the ICC with some historical achievements, political interferences by many international actors, both at state and non-state level. You've also against the former Israeli Prime Minister Ehud Barak in Los Angeles and the Israeli state in Washington, D.C. What were these cases about and why were they filed in the United States? Please give us some.
Thank you. Assalamu alaikum to all of you. Thank you, first of all, for organizing this event where we can get together to share ideas and consolidate our efforts together, hopefully. The cases that we've been dealing with as a law firm started in 2014, actually, end of 2013. Just to give you background information, Mavi Marmara Flotilla victims have filed cases at International Criminal Court for some time, culminating with the state of Comoros, which was the flag state of Mavi Marmara, agreeing to open the case as a founding member of International Criminal Court. The legal team at the time, led by Sister Buldan Sönmez, filed the case at International Criminal Court in May 2013, the first step at the state level. The Rome Statute allows such applications, especially from member states, to be fully considered. You all know, I don't have to kind of tell you how Israeli lobby, backed up by most of the Western governments, really works hard to challenge any legal attempts made to hold them accountable for what they do. This is obviously Gaza Flotilla attack is not the first of murdering practices of Israeli state and its army. That said, the prosecutor used a minute reason to try to refuse the application made by the Comoros and the victims, two separate applications. The application submitted in 2013 was refused in November 2014, which is when we were involved after the refusal as a law firm. Immediately after that refusal, we've appealed to the pre-trial chamber for the decision to be re-evaluated, because she admitted, Madam Prosecutor admitted, that Israel committed war crimes. So it's in the court record that Israel committed war crimes. But then it becomes, so what? Because Israel has, enjoys such impunity, it seems. And she tried to use an argument that this was not big enough murder. This was not big enough crime. This was not big enough for her and her office to evaluate and basically take it to a level up. And she tried to argue a point that she was the gatekeeper at ICC and that it was her decision to open or not open a case, and not necessarily anyone else's within the system of ICC, which is what we challenged. We challenged her reasoning. We challenged her argument that only she had the authority to open up the investigation, blah, blah. So the reason why things have changed in ICC since this particular case, which is what really makes Israel quite angry, is because we keep defeating that argument. No, this is not a small case. Your office is duty-bound to investigate this crime, and that you're not the only authority in ICC to open up. And the pre-trial chamber three times agreed and sent the decision back to her. And let me break that down for you guys. In 2015, January, that's when we started the first appeal to pre-trial chamber. Pre-trial chamber then basically said to her, they are right, you're wrong, re-evaluate this evidence submitted to you. Gravity is not a reason. She said, no, the gravity is the reason. I looked at the evidences, and therefore my decision stands. Second time. The pre-trial chamber, we appealed again, and pre-trial chamber said, no, you're wrong, and you have to evaluate it again. She refused with the appeal chamber, which is like a level up. The appeal chamber judges, panel of 5, including the president of the International Criminal Court, and most senior judges have turned around and said, your attitude is wrong, your argument is wrong, evaluate the application made by the founding member states, and the evidences needs to be evaluated properly. This is the third time. So now we are at the stage where yesterday at 4 o'clock, we filed the 4th appeal, that she has now dismissed the appeal panel's view, insisting that she is the only one who can actually make the decision, even though the panel judges, including the president, said you're not. And the judges can actually direct the prosecutor to look at this evidence and maybe even direct her to kind of open up the cases. But anyway, point is, there has been a major breakthrough in the inner workings of the International Criminal Court, and really undermining the position that she keeps taking. And she is under the pressure, and we've actually exposed her by some of the works that we've done and said, look, you're basically playing into the hands of the politics here. You're no longer acting as a Madam Prosecutor, the prosecutor of ICC, because the whole application has been going on for 6 years. It's on the right side of the law, the Rome Statute. Every single section of it, we fit in. There is no reason except for you to open up this case, and you're just acting politically here. We accused, and we asked her to be sanctioned in our last application, that the Madam Prosecutor is acting outside of her jurisdiction and that she needs to be sanctioned. We asked her to be removed because this is now ridiculous. You're basically playing Israeli card. The prosecutor, one of the things we did, the appeal panel asked us to submit an oral argument, which we did at the International Criminal Court, which was a broadcast live. You should have seen it. They were acting as if they were the Israelis, defending the argument that the Israel was right to do what they were doing. And that wasn't even the subject of discussion at the time. The subject of discussion was the inner rulings and regulations of the International Criminal Court, not whether Mavi Marmara victims were right or Israel was right. It was about the inner workings of the means and stuff. But the prosecutors that actually came to the oral hearing were defending Israeli actions, saying they were being attacked by the civilians that was on the boats at the time. So this is going on still. We've not given up on behalf of the state of Comoros and the victims. We represent hundreds of victims, and their arguments in the International Criminal Court stand still. And we have been quite successful in the sense that we've defeated twice the interjection by Israeli state. There's an organization called Israeli Law Center. Most of you probably know about them, Shura Din, which is formed in 2002, led by this lady called Nitsana Darshan Leitner. She propagates herself to be a human rights lawyer, fine. But what she does is she tries to sabotage any case that's taken against Israel. That's what they do. And they admitted in 2017 that they were backed by and supported by Mossad. They tried to intervene in our case twice. On one occasion, submitting fake, made-up documents that we investigated and unearthed that it was all made-up documents submitted by this organization to International Criminal Court. We're grateful that the ICC judges did not take it into consideration and dismissed it. And this isn't the first time, of course, Israel tries to intervene. Here at the International Criminal Court, they failed to make any effect to what we were doing. But they did succeed in our cases in the United States. We filed a case in Washington, which at the initial stage refused. We filed it against the state of Israel, the Prime Ministry, the Navy, and the intelligence services, etc. Anybody who we felt that had a connection to the attack on the flotilla, we took them to court. In Washington, if you're going to take a case in the US against a state, you do it in Washington. That's what we did. We've got refused, which we were expecting, and then we went to the appeal. The 3 panel judges ruled against us, and obviously the fact they've used was the United States government, through its State Department, have intervened into the case by submitting suggestion of immunity. I think, if I remember correctly. That they actually said it would be against the national security of the United States if the case against Israel was to go ahead. A clear victory for Israeli, of course, politicians and the state apparatus. So the case was dropped. The panel of judges basically tried to use an argument to drop the case, which is something we later on afterwards, we suffered similar in Los Angeles. In Los Angeles, we found out that Ehud Barak was giving a speech in 6 different locations during the conference.
Speak to you.
Sorry. Did you say something, Zinat?
Go ahead, Hakan. No, that might have been some interference from one of the other speakers. Okay. We'll make those unmuted.
So we found out, we've got the intelligence that Ehud Barak was doing a conference in 6 different locations. So I formulated a team immediately, legal and the detectives. So we've kind of recceed out the locations where he was going to give speech. We prepared the indictment. And in US law, if you can't serve on the person, then the case that you file has no validity. You got to serve. And in an unprecedented way, we've kind of using different tactics, which one day I'll probably reveal in the future, to overcome the Secret Service and the Mossad and the local police to basically serve on Ehud Barak in Los Angeles. And we sued him successfully. And the case was going on quite brilliantly. Again, at the initial stage, we knew we were going to be refused because at the local level, the judge may not necessarily understand, and he didn't, and he refused. But then again, we went all the way to Ninth Circuit, if I remember correctly, the number. And then the United States government intervened in the case again, and they've shut it down. They've shut down if you guys remember, one of the shaheeds, one of the martyrs that was killed, 10 of them out of the 10, youngest one was Furkan. People think Furkan was dual national, Turkish and American. He wasn't. He was an American national. He didn't have a Turkish nationality. He had a leave to remain, like permission to live in Turkey, even though his dad and mom are Turkish nationals. He was an American citizen, straight. And so we were running a case on behalf of an American national, and the American state intervened in the case. And this was a civil case. We were seeking compensation. Again, they had the top lawyers to represent the Israeli state there, Ehud Barak, etc. Shuraddin intervened on that case as well. They didn't succeed for us to actually get to that level. But then the American government used its executive power to shut down the case against Israel, which is another kind of indication of how much this country, Israel, enjoys such immunity. And it is the lawfare, as my friend Ziad talks about, that we have to continue against such atrocities the state still commits. In our time, if we don't take the responsibilities of upholding the rule of law and the rights of any individual, then we're not doing our job. Just like how generations before us actually did it in South Africa. This state is to be held accountable for what it does. It still does. The ICC case is still ongoing. We're not obviously going to give up. I could kind of report to you, without revealing any information, that there's a case we've been preparing for some time as a firm. We are looking at this whole ongoing conflict with the state of Israel from a different perspective. And we are using a lot of different tactics, not necessarily international criminal law, but there are other avenues that are available that we are working on. Hopefully, we want to hold them accountable for what they're doing using different tactics. Asymmetric lawfare is the name of the game, to be honest with you. And this is the only way where we can actually try to get at what they're doing and hold them accountable for what they're doing. There are so many Achilles heels they have. It's just about finding the right ways of dealing with it. And so we are working on 2 separate projects. Hopefully, I don't know yet, but we're working on it. And I'm sure there are many of you who have different projects and ideas that you guys are working on. The message from us as the law firm that's representing most of the victims of Mavi Marmara Flotilla, your brave souls, your brave actions are not going to go away by their persistent interfering in illegal cases. As long as a single soul out there that's fighting for the right cause, this case and this cause will be defended, and we will write our names and our actions into the history. We will win. And by simply continuing our struggle and not giving up, we will win. And it is in that kind of spirit and hopeful mindset that we go on all together, all of you guys, all of us. One day we will see, hopefully, inshallah, the end of this apartheid state of Israel. Thank you for giving me the opportunity to be speaking to you. And if you guys have any questions, I will wait for them and answer them.
Thank you so much, Hakan. Inshallah, as you say, we hope to see some victory. You've given us quite a lot of insight into the frustrations that you've experienced with the pre-trial and the ICC. And I think Catherine has also had been part of this. In December 2019, as you've mentioned, the ICC prosecutor concluded that there is a reasonable basis to proceed with an investigation into the Israeli war crimes and crimes against humanity. In March of this year, there was the submission, and then, as you've said yesterday, once again, some movement in terms of the case being put forward at the ICC, but a lot of resistance as well. I'd now like to invite Catherine to weigh in on this. I understand that she has, as part of the Center for Constitutional Rights, joined more than 180 Palestinian regional and international human rights organizations in signing this open letter to the ICC prosecutor expressing support for the opening of an investigation. That this must have been an intense process to reach this point, as Hakan has already alluded to. Do you believe that the submissions provide sufficient evidence for the pretrial chamber to determine the scope and territorial jurisdiction of the court? Are we going to see any movement on this, or will we continue to be butting heads with the ICC? Catherine?
Sure. Well, thank you for inviting me to join this webinar. And I'm going to start by saying I'm in a location that, again, is having severe storms. So I hope that the internet connection can be maintained. And if I need to, I'll turn off video to just keep going. But so far, so good. So I do also want to acknowledge the anniversary that this webinar is commemorating, a very sad anniversary, the attack on the Solidarity Freedom Flotilla that was going to show international solidarity with Palestinians in Gaza. And here we are 10 years later. 10 individuals lost their lives when the 6 boats of the flotilla were attacked in international waters. And 10 years later, Gaza is still closed to the outside world. So I just want to start by recognizing those who go on the Freedom Flotillas and the very, very sad reality, not only but also for the Palestinians in Gaza, that they remain under closure. The Center for Constitutional Rights, in the context of the flotilla, we submitted a series of Freedom of Information Act requests to the US government. As was just mentioned by Hakan, one of the individuals who was killed, Furkan Doğan, an 18-year-old US citizen. Also, there were boats in that flotilla flying a US flag and Americans on a number of those boats. So we wanted to know what the US government knew beforehand and what it did afterwards. So to those who are interested in seeing some of the responses that we got to that many years of litigation of the flotilla FOIA, you can go to the Center for Constitutional Rights website. I also just want to acknowledge a term has been used a number of times in this webinar, lawfare. And this is a term that is used by many sides, both positively and negatively. I am an attorney who represents individuals who've been subjected to serious violations of international law. I work in US courts, I work at the regional level, and then I work internationally as well, using both civil or criminal law. I do not consider that I engage in lawfare. I consider that I am just seeking to use the law for positive change and to achieve some measure of equality for all victims, to hold everyone equally accountable before the law, and to hopefully get some measures of redress to try and deter future crimes. So, I think we are hearing a great deal of frustration with the law thus far, being able to actually achieve accountability and deter international crimes. But I'm committed to continuing to represent victims so that they too have an equal access to justice. So that is the context in which I see my work. There was discussion from Hakan on the ICC proceeding started by the there are 2 separate cases at the ICC. And so the case that I am involved in is the situation of Palestine. So in 2015, the state of Palestine actually acceded to the Rome Statute, which is the statute governing the International Criminal Court and became a state party. And under the Rome Statute, the prosecutor can investigate crimes either committed by a national of a state party or on the territory of a state party. So crimes either by Palestinians committed anywhere in the world or on the territory of the state of Palestine because of the fact that Palestine became a state party. And as has been discussed, there have been a number of investigations into crimes committed on the territory of the state of Palestine over the last decade, or certainly at least the last decade, but for longer, in the context of the Israeli occupation of parts of Palestine, including the West Bank and East Jerusalem and the Gaza Strip. So with the ICC having jurisdiction over the territory of the state of Palestine, and Palestine gave that jurisdiction back to the date of June 2014, right before the 2014 military offensive on Gaza, the prosecutor can examine all of those crimes. And when she finds that there is a reasonable basis to conclude that crimes within the jurisdiction of the ICC, so that could be crimes against humanity, war crimes, genocide, and more recently aggression, have been committed, she can open an investigation. So in the context of Palestine, the prosecutor has been looking for 5 years, a remarkably long time, a frustratingly long time, to determine whether that low threshold of reasonable basis has been satisfied. Palestinian human rights organizations, and I really want to give credit to the Palestinian advocates, activists, lawyers who have been so central in why it is also that the ICC is looking at the situation of Palestine. There are so many brilliant, dedicated Palestinian human rights lawyers who have brought this case forward. So while I am speaking as a US lawyer, it is really the work of Palestinian lawyers that got us, the international community, to this place. So the prosecutor is looking, and she was able to conclude, yes, a reasonable basis. At the same time, the state of Palestine, as a state party to the ICC, asked the prosecutor to move forward the investigation. So in December of 2019, the prosecutor announced that she would like to be moving forward with that investigation. And she asked the pretrial chamber of the ICC to confirm that the territorial jurisdiction for Palestine does in fact include the West Bank, including East Jerusalem, and the Gaza Strip, and that this is the place where she can investigate. And there has been, as you mentioned, a tremendous amount of attention on this question. There has been briefing through February and March on this question. We will see more briefing before a decision comes. I am one of a number of lawyers who represent Palestinian victims who were able to put forward their views to the pretrial chamber. There were, I believe, 9 sets of Palestinian victims and 1 set of Israeli or non-Palestinian victims who put forward submissions. And for the 20 individuals who I represent, who claim that they are victims of the crime against humanity of persecution, which is the denial of fundamental rights on a discriminatory basis. So they are asserting that they are denied basic rights like the right to life, the right to be free from torture, the right to a livelihood, the right to family, the right to education, the right to travel, the right to health care, all of these rights because they are Palestinian. And the individuals who I represent come from all parts of the state of Palestine as well as the diaspora. And so we are encouraging and asking the pretrial chamber to indeed confirm the ICC's jurisdiction and to have that investigation opened straight away. It has been way too long. We believe that these 5 years of preliminary examination. At the same time, we recognize that the prosecutor is being very careful and professional in the steps that she is taking. We believe sometimes too cautious, but she is also coming under significant attack from the side of being seen as being biased in favor of Palestine. So it's notable that there are many views of the way the prosecutor might be acting. What is clear, however, is that the International Criminal Court is under
We seem to be losing Catherine on audio. I think that she has enlightened us.
There have been very blatant. Can you hear me?
Yes, we can, Catherine.
Okay, I'll try and continue, and I'll be brief.
Please, we do have to speaker as well, so if you could wrap up.
Yep. Just that while we are waiting to the outcome, we recognize there are political pressures, strong political pressures being ICC from Israeli and US officials through public statements. But we believe that it is appropriate for the ICC to be looking at the situation of Palestine. This is a court of
Okay, there appears to be too much interference in terms of Catherine's presentation, and I think that we would have to move on to the next presenter. Thank you so much, Catherine, for staying with us as long as you've been able to, and we understand that you are having technical problems in the area that you are in. What Catherine has enlightened us on in terms of the ICC and the Rome Statute is quite important, and our next speaker has worked with the issues of the Rome Statute.
The crimes by Israeli officials.
Yusha has been involved in a number of cases that have linked to the Rome Statute. I'd like to introduce some of the issues in terms of the Gaza docket. Israel, through its military and technological prowess, has expanded its tentacles across the world. The Israeli Defense Force enlists people from everywhere, including from South Africa, and Ziad alluded to this as South Africans who have been enlisted into the Israeli Defense Force. Yusha, the weighty document known as the Gaza docket has gained traction in South Africa, and as it sought to identify and prosecute South Africans who serve in the IDF. Please share with us the process of this case and how similar prosecutorial moves could possibly be taken in other parts of the world. You've also worked on human rights cases such as the Rohingya, Kashmir, Ogaden. These are people and regions that have experienced apartheid in different forms. In all of these areas and cases, there is evidence of Israeli complicity. How can this be addressed?
Yeah, thank you, Zinat. To the organizers, Bismillah ar-Rahman ar-Rahim, Assalamu alaikum wa rahmatullahi wa barakatuh. To everybody who's participated in the organization of this event, thank you, moderators, organizers, co-participants, thank you very much. So I'll deal with the 73 identified South Africans. I'm sure there's substantially more, but we haven't yet been able to find them, and the search continues. The webinar is already having some serious effects on me in the sense that we're having these various complaints against prosecutors of the ICC. We also have them against our local prosecutors and the local police in our country, unfortunately. So if I can just, before I get into the Rome Statute, because the Rome Statute has what we call international application, in that it is a localized statute with international stretch in the event that its contents are needed, and I'll deal with the Rome Statute shortly. But in South Africa, when a crime is committed, the victim of the crime, or victims of crimes, but victim of a crime, is obliged to report that event, that crime, to the local police. the local police then take a statement from the victim with as much evidence as possible, and hopefully identify a perpetrator and then pursue the perpetrator. The police are entitled to seek the assistance of the prosecuting authority, and that prosecuting authority generally will guide the investigation insofar as is necessary if the police require the assistance. Otherwise, the police are tasked with effecting arrests or summoning people to court in order to answer for the crimes. And so what transpired in the period December 2008 to January 2009 was Israel's operation called Cast Lead upon Gaza. And at the time, there was a South African, a Palestinian married to a South African by virtue of which he gained South African citizenship, Haider Eid, who was a victim. And that will become relevant to you when I read the relevant section of the Act to you. But there were also other jurisdictional grounds on which we could challenge it, but primarily we used Haider Eid. And at the time, the PSA, Palestinian Solidarity Alliance and Media Review Network had approached the Muslim Lawyers Association, and I was tasked as the attorney of record, ably assisted by a number of other attorneys, colleagues in the Muslim Lawyers Association. So we then looked at the legislation that was available to us, and we came upon the implementation of the Rome Statute of the Criminal Court Act of 2002, known in the ICC as the Rome Act. Post 1994 and subsequent to the end of the apartheid system in South Africa, our government at that stage had very noble intentions in adopting various means of international legislation to comply with its obligations as a new democracy, as a human rights foundation, and all of those things. Unfortunately, those have dissipated somewhat because there was a very hasty, unprofessional attempt to try and bail out of the Rome Statute, which I have no doubt is still on the government's table, but hasn't yet been done. But they certainly tried to do so very hastily and unprofessionally approximately 3 years ago. So I'm going to do a bit of reading for a while, but essentially, and it's important for other jurisdictions who have adopted the Rome Act into their legislation to consider utilizing it because it was adopted wholesale as presented by the ICC. And so the preamble to the Act provides as follows: to provide for a framework to ensure the effective implementation of the Rome Statute of the International Criminal Court, to ensure that South Africa conforms with its obligations as set out in the statute, to provide for the crimes of genocide, crimes against humanity, and war crimes, to provide for the prosecution in South African courts of persons accused of having committed the said crimes in South Africa and beyond the borders of South Africa in certain circumstances, to provide for the arrest of persons accused of having committed the said crimes and their surrender to the said court in certain circumstances, to provide for cooperation by South Africa with the said court, and to provide for the matters connected therewith. So very nobly intended, but unfortunately, prosecutors and police putting hurdles and logistical implementation of this in our way. The preamble goes on and says, further and mindful that, and this is important in regard to the link between apartheid and Israel, throughout the history of humankind, millions of children, women, and men have suffered as a result of atrocities which constitute the crimes of genocide, crimes against humanity, war crimes, and the crime of aggression in terms of international law. The Republic of South Africa, which with its own history of atrocities, has since 1994 become an integral and accepted member of the community of nations. The Republic of South Africa is committed to bringing persons who commit such atrocities to justice, either in a court of law in the Republic in terms of its domestic laws where possible, pursuant to its international obligations to do so when the Republic became party to the Rome Statute of the International Criminal Court, or in the event of the National Prosecuting Authority of the Republic declining or being unable to do so in line with the principle of complementarity as contemplated in the statute in the International Criminal Court, created by and functioning in terms of the said statute, and carrying out its other obligations in terms of the state statute. The section which establishes the jurisdiction for South African courts to intervene is section 4, which says in paragraph 1, despite anything to the contrary or in any other law of the Republic, any person who commits a crime is guilty of an offense and is liable on conviction to a fine of imprisonment, including imprisonment for life, or such imprisonment without the option of a fine, or both a fine and such imprisonment. 2, despite any other law to the contrary, including customary and conventional international laws, the fact that a person A is or was a head of state or government, a member of a government or parliament, an elected representative or government official, or being a member of a security service or armed force was under a legal obligation to obey a manifestly unlawful order of a government or superior is neither a defense to a crime or a ground for possible reduction of sentence. So we can prosecute heads of state here. 3, in order to secure the jurisdiction of a South African court for purposes of this chapter, any person who commits a crime contemplated in subsection 1 outside the territory of the Republic is deemed to have committed that crime in the territory of the Republic if that person is a South African citizen or that person is not a South African citizen but is ordinarily resident in the public. And importantly, the basis of the Gaza docket, C, that person after the commission of the crime is present in the territory of the Republic, or that person has committed the said crime against a South African citizen or against a person who is ordinarily resident in the Republic. That's our Heider Eid. So the jurisdictional grounds were established. And what we were then able to achieve through an evidence gathering exercise after CAST-led was extensive evidence of war crimes and crimes against humanity secured by people who like Heider Eid, who was a South African who was a victim in the process, and a number of Egyptian doctors who had treated victims of the operation CAST-led. And what we found in all of that was that there was extensive evidence of the use of white phosphorus gas as a weapon, when in fact it should only be used for lighting, the use of drone technology, the usage of nail bombs and fletchets, the bombing and targeting of United Nations shelters, the targeting and destruction of places of worship, and the denial of humanitarian assistance. There was also the disproportionate use of force and war crimes. There was specific reference and evidence to the targeting of children. That, in essence, was contained in the docket with supporting evidence. The docket was presented to the police and the National Prosecuting Authority in August 2009. And the response we received to that part of the docket was that there was no investigation possible on the basis that the anticipated presence of the accused in South Africa was not real. My colleague Ziad earlier referred to the South African Litigation Center decision, which went up to the Constitutional Court, which in fact has now ruled that the actual presence is not required and that an investigation can commence in absentia. And so what the Rome Statute then anticipates is that once that investigation is complete, the prosecuting authority either establishes a court in South Africa to prosecute the crimes based on the evidence, or if it is unwilling to do so, then to onward refer the matter to the ICC. The second part of the docket pertained to evidence that we were, members of the South African public who will remain anonymous for the purposes of this webinar, were able to obtain information and infiltrate a number of Jewish South Africans' Facebook accounts, where these Jewish South Africans were boasting about their participation in the IDF, and in some instances holding up the new South African flag together with the Israeli flag, and dressed in full military regalia in most instances, and boasting about their experiences. We were able to give this evidence to the SAPS, and we requested an investigation. Through this process, we also found that locally 2 police stations, being one in Norwood and one in Sandringham, were being utilized as recruiting officers for this rite of passage of Jewish South Africans to go and serve in the IDF. This was in breach of local legislation known as the Foreign Military Assistance Act. The answer to this, and it appeared as though, well, it was, the factual matrix in which they would leave the country would be on a South African passport to a European or other destination, not Israel. And then they would use an Israeli passport secured for them through the means of recruitment through what we identified as Norwood and Sandringham police stations where there was also ongoing training, and would utilize a different passport to then travel from that European or other destination to Israel, do whatever they needed to do there, return to the European destination and fly out to South Africa. That's the pattern we picked up. And when we interrogated the policeman who was tasked with investigating this matter, the simple answer we got from the local police was that he had requested this information from the Israeli embassy in South Africa. They had indicated that they would not assist in any way, and that's where he closed his investigation. Even though we requested that anyone, or at least the 73, be interviewed in order to ascertain whether they had or had not traveled, the request was refused. And so in July 2011, we brought what is called a review application on the basis that these administrative authorities had not properly done what we had asked them to do, both in the complaint in respect of the war crimes and crimes against humanity and the 73 South Africans. And at about that time, the then Israeli Labor Minister, Tzipi Livni, was supposed to have traveled to South Africa. So together with the review application, we brought what is called an application for the warrant of her arrest. That was submitted to the National Prosecuting Authority and the SAPS, and while they were considering it, we received news that she had cancelled her trip. We had used the similar provisions to stop General Sisi also traveling to South Africa, but I understand that he subsequently did so secretly, but at the time we were able to stop him. The state's response I've discussed has been that the anticipated presence is required. That has been refuted now in the South African litigation center matter. And so that part of the review application should be a mere formality in court, we hope. And it should, the decision is just the same. We're on all fours with that decision in regard to our request. And in regard to the 73 South African accused, we are hopeful that the court will order the police and the prosecuting authority to do substantially more. That's the Gaza docket in a nutshell.
Thank you very much, Yusha, for keeping to your time and for also enlightening us about the Gaza docket, relying quite heavily on the Rome Statute. If I may ask, South Africa was considering withdrawal from the Rome Statute not very long ago on the basis that the ICC has unfairly discriminated against African countries. How would that affect the Gaza docket? Yusha, if you can unmute yourself before speaking, please.
Yeah, too much technology for this old man, I'm sorry. Yeah, so look, we don't know the details of it because there was, what I said, a very hasty and unprofessional attempt to do so. But that certainly seems to be the intention, and one hopes that it will not have what is called retrospective effect, so that what has been placed pre-abolition of the provisions must still continue and anything thereafter. But it could quite be because the attempt to get out of it was on account of Bashar al-Assad's visit to South Africa and the fact that the ICC had issued a warrant. Sorry, Umar al-Bashir. My apologies. Umar al-Bashir's visit to South Africa, and that certainly seems to be the view. But there's a whole host of processes that they would need to follow in order to get out of the statute, and that's why I said to you the intention post 94 appeared to be very noble, and I don't know if we're using our nobility in essence, or whether it is being used as a mechanism for prosecuting Africans only. That certainly seems to be the impression, but it also seems to be the thread of the prosecutorial attitude that Hakan and Catherine spoke about earlier, is the pressure being brought to bear on these prosecutors not to act against other governments or individuals.
Thank you, Yusha. We have entered into our Q&A session, and there are a number of questions that have been put forward by our listeners and viewers to this webinar. Before I delve into those formal questions, I have one more question for you, Yusha. You alluded to the regulation of the Foreign Military Assistance Act in South Africa, and that was later followed by the prohibition of mercenary activities and regulation of certain activities of citizens, South African citizens in armed conflict. Can these two acts be utilized in addition to the Gaza docket and the Rome Statute in prosecuting those 73 South Africans who are participating in the IDF?
So at the okay. So at the time of the delivery of the Gaza docket in 2009, the Foreign Military Assistance Act was not as extensive as it is currently now. So previously, you know, if you had to show active participation in military activity with a country at war at the time. That was what the 2009 legislation at the time stipulated. The current legislation makes it substantially worse. And we're not entirely certain whether that was motivated by open and democratic thinking. We seem to think that amendments were necessitated by the presumable Muslim threat across the globe. But it essentially is substantially worse, where even if you cooked for an organization of war or sewn a button on the soldier's jacket, you can still be prosecuted. So the act is substantially worse, and certainly these acts will not be, the 73 that we found will not be prosecuted in terms of that legislation. But certainly, if we can find these Jewish South Africans who continue to travel, we will certainly use the new act because it's substantially more stringent in its regulations of service for a foreign military at war at the time.
Thank you, Yusha. I'm going to move on to the questions that have been posed. I'm quite pleased to see that the South African delegate on the Mavi Marmara, Khadija Davids, has joined us on this webinar. Khadija has put forward 3 questions. The first is, to what extent did the politics prevalent in South Africa and Turkey affect attempts to hold the Israeli regime accountable for the crimes committed on the Mavi Marmara? Second is, it's been a decade since the attack. Has there been a change to the legal landscape in both countries that could see progress on the matter? Thirdly, Israeli disregard for international law is well documented. Is there more positive actions coming from the ICC in holding them accountable for the violations? I'd like to address these questions to Ziad and to Burak on the issues of the Mavi Marmara, and perhaps to Catherine and to Hakan on the Israeli disregard for international law.
Thank you. Thank you, Zinat. The first question about the politics prevalent in South Africa and Turkey, it's a very complicated situation. Speakers have spoken about South Africa domesticating the Rome Statute and principally us using the International Criminal Court Act. Using that piece of legislation has allowed us to bring Khadija's case before the South African authorities. What's important, however, is to understand that the diplomatic agreement that was entered into between Turkey and Israel impacted on Khadija's case. What needed to be considered was that South Africa had one citizen, and we know that the Mavi Marmara had a host of humanitarian aid activists, journalists, and others covering the blockade and breaking the siege of Gaza. And these activists came from across the globe, and including the 10 Turkish citizens, 1 US Turkish citizen that was also killed or martyred. So because of the process that was followed in in the Istanbul Criminal Court, where evidence was preserved and many activists from across the globe that were on the Mavi Marmara and on the Flotilla 8 vessels tendered evidence in that court, but also in absentia of the 4 Israeli IDF commanders. The important process was that there was a preservation of evidence. Now, South Africa doesn't have that kind of avenue of preservation of evidence. We have something what you call the Anton Piller rule that's used in civil cases to preserve evidence when there's a fear that certain evidence may be destroyed depending on pending litigation. But because of the process that was being followed in the Turkish court, and Khadija being a South African citizen, we utilized the principle of mutual cooperation between South African authorities and the Turkish authorities. And that was what was important, is that the IDF arrest warrants that were issued out of the Istanbul Criminal High Court were then utilized or invoked here in South Africa by means of advising the investigative authorities to say, we're going to issue a red alert, or not a red alert, we're going to list those names on South African border control, so that if any of those IDF war criminals do decide to come into South African territory, they would immediately be arrested, and not for the trial to be convened in South Africa, but to be extradited to Turkey, to the Istanbul Criminal High Court, to face charges there. So the South African case was very reliant on what was going to be the outcome in Istanbul. So from that aspect, I would say that that was, maybe perhaps the challenge in Khadija's case, but still on the decision books of the South African Police Services and the Director of Priority Crimes Investigation, that listing on border control exists, and we would utilize those means at any given opportunity to ensure that even if the process in Turkey doesn't continue, or there isn't the traction that is required at the International Criminal Court, because I had considered that as an avenue because of the bilateral treaty and what was going on in Turkey, is to evaluate what's happening at the ICC in terms of the Comoros, what Hakan has been representing, the state of Comoros in the ICC case, to say that if the ICC case would then, apply itself and convene a trial for the victims of the Mavi Marmara and hold Israel accountable, then I would certainly approach South African authorities to request not me as the attorney representing Khadija, but as a state, the South African state making a referral to the ICC, requesting that Khadija's case be joined to the ICC on the state level basis. So that certainly is still an avenue, depending on what would be the final outcomes at the International Criminal Court. Zinat, is there anything else you require me to answer?
Would hand over, it would be for Burak to answer the question that was posed to him. Thank you.
Thank you so much. For these two questions, actually I can answer both of them together, I think. To be honest, until 2013, until the agreement, firstly apologize from Netanyahu to our Prime Minister, and after that the agreement period in 2016, I can say that Turkish political situation was behind of these cases, and it was affecting and supporting. They were supporting the cases period, and for that, as you know, Turkey is the center of these cases, and all the evidences is here. The ship is here. The witnesses are here. So it was affecting all over the world. The activity, the legal actions in all over the world was affecting by Turkish legal process. And until 2016, until the agreement date, I can say that Turkish political situation, Turkish political authorities was behind of Turkish legal process. But after this agreement, I can say that it was stopped. And right now, we don't have any progress. And I can say that we went back because we had a case, and this case was affecting all over the world, but right now it was dismissed. So I can say that honestly, the political affection of these cases in Turkey was stopped. So we only have this appeal period. We are hoping to take a decision from the High Court to change this situation. But because of the political relationship between Turkish government and Israeli government, I'm not optimistic for that. For legally, as a lawyer, we are hoping that, and we are we are doing our best, but repeating again, for the political relationship between Turkey and Israeli, I don't know, with the necessity of the governmental authorities is not, doesn't like that. I think this is the answer. Now we are back. We don't have any progress. We don't have any progress, unfortunately. We are hoping only to finish this appeal process, and we are taking a benefit from that, inshallah.
Inshallah. Thank you very much, Burak. Hakan?
Right. So the immunity Israeli enjoys. For many who actually look very closely into Israeli psyche, it is a religious duty. They actually see their soldiers and their military as soldiers of God, that they have some kind of a manifest destiny. This is how they truly believe in this concept. And in their mind, they cannot do no wrong. And what they do is justified. And to this end, it is a policy, a government policy of Israeli state to do whatever it takes to defend their glorious military from being prosecuted. You can see evidence of this quite clearly. There has been no case successfully against Israeli military. And that's because every time there's something happens, they actually fight it, you know, tooth and nail. And it is a practice that is expected. This is the key word here. That's expected as part of the package. Most recent evidence of it is the Netanyahu government. As you know, it's been over a year they've been negotiating to form a government. And as soon as they form the government, what is it they announced? The first thing they announced, they have announced a ministerial position for someone to fight any legal cases against Israel, especially obviously talking about the cases that we're doing in the International Criminal Court. So they now have a minister in charge of tackling any legal case against Israel, Israeli soldiers or police or whoever is basically murdering civilians almost every day. It goes to show the mentality these people have. And so they will do whatever it takes to protect themselves from such legal challenges. And so it's not just they enjoy the impunity given to them by whomever they see as their ally. They actively make things possible and happen so they can actually enjoy the impunity that they get from wherever. Our friends in South Africa talked about some of the examples of how I personally have been dealing with it for years. You, all of us, have in one form or another have witnessed how much this particular state enjoys the status of being untouchable. But obviously this is a false notion. Eventually it will happen. Eventually they will be held accountable. There will be accountability. They will be. So at the moment, as part of the team that actually suffered the impunity that Israel enjoys, I can tell you they do. But I just don't see this happening all the time. This is a strong position maybe now, but it is temporary. We will eventually prevail, and Israel will not enjoy the impunity that it does. So it's factually correct at the moment. That is what's happening. It's open to challenges, and that's what I suppose that's what we're all doing. Thank you.
Thank you very much, Hakan. We have a couple of questions directed to Catherine. I hope she's still with us. The first says, I understood Catherine to be saying that she does not see herself participating in lawfare, which she acknowledges is a tactic adopted by both solidarity lawyer activists and the State of Israel. I would like to ask Catherine whether I understood her accurately, and if so, if she could explain why she does not characterize her practices as lawfare. The second question directed to Catherine, if the ICC can drag its feet for 5 years before it finds any reasonable violation of the international law against Palestine, how does one ensure justice for Palestine sooner rather than later? I don't understand the hesitation. Can you talk to this point, please? Catherine, are you still with us?
I hope so. Can you hear me?
Yes, we can.
Can you hear me? Okay, I won't turn my video on. I am in New York. You would think I would have good internet connection, but I'm outside the city, which is why the very bad connection in a storm. I'll start with the second one. It is indeed, as I said, and the questioner agrees, extremely frustrating that it took 5 years to reach the point of the prosecutor determining that there's a reasonable basis. Part of why it took so long is that there have been many legal threshold issues put forward to say that this case should not be able to proceed. Questions such as whether Israeli nationals can be brought before the ICC since Israel is an state party. Questions about the effect of the Oslo Accords. Questions about whether or not somehow justice and peace processes are incompatible. And so I think that for the prosecutor's office, as we saw in her very lengthy submission of December, when she said, I can proceed, she has been looking at a range of legal questions and policy questions as to whether or not it's not only possible but appropriate for her office to exercise its investigative powers and later its prosecutorial powers. One of the things that the ICC statute has built in, or that has really come to be part of the policy of the prosecutor, is that cases are brought only against those who bear the greatest responsibility, and that there's a certain gravity threshold. This is precisely what has been the issue in the Flotilla cases, whether or not the death of 10 people and the other crimes committed against the other Flotilla passengers is of sufficient gravity. When it comes to the collective crimes committed on the territory of the state of Palestine, whether from the 2014 military assault on Gaza, whether out of the settlement enterprise, whether political prisoners, whether crimes against children, there's no doubt that these crimes do satisfy that gravity threshold. And we hope that despite the real range of legal questions that have been thrown at the Palestine situation, very uniquely thrown at the situation, with the help of the amicus briefs that went in and the submissions by the victims, that the prosecutor does indeed proceed expeditiously, not only to investigate, but to bring cases to prosecution, because that is the way to defer these future crimes. On the first question about lawfare, it's not a negative comment for anyone who does embrace that term. You know, I come out of an anti-militarism background, and to some extent that term has been used to suggest that there is war by other means. I think to seek to have law, especially international humanitarian law, that is supposed to be used to protect civilians, to try and have that law enforced so that war crimes and crimes against humanity are not committed. I don't see that as either a political act nor a form of warfare by another means. I simply think that each person enjoys the ability to be protected by the law, and each person should be held to account under the law. So again, because it can be used positive and negatively, I appreciate that many people might embrace that term. It's just not one that I associate with how I.
Thank you, Catherine. We have just a few more minutes before we have to close this webinar, and there's just a few short questions that have been posed. I'll try and combine some of them, and let's hope that these can be addressed quite succinctly. One of them says, any comment on the United States repealing or denying visas to International Criminal Court staff seeking to investigate Americans in Afghanistan or elsewhere, and may take similar action to protect Israeli or other allied forces from prosecution, according to Secretary of State Mike Pompeo on March 15th, 2020. Hakan, if I could ask you to please address this question.
It's just funny. They actually, on one hand, threaten the International Criminal Court. As you do know, all of you guys are observant to the Americans' hostile policy towards International Criminal Court. Even though they're not party to it, America is not. Afghanistan, of course, is. But the fact that American soldiers have committed multiple war crimes in Afghanistan is an issue. It is out of that fear, because somebody will do it. I know for a fact the Afghanistan government right now in power is seeking help and assistance from international lawyers. One of two of them is well known to most of you, who is advising the Afghan government for upcoming cases. There are cases that will come. Pompeo, not just Pompeo, but John Bolton, in a very brazen attitude of a statesman, have actually threatened personally the judges of the International Criminal Court. In answering earlier to Israeli impunity, can I combine that with this? I'm hopeful because I'm a believer in rule of law. If you don't have rule of law, we have nothing. So I believe in it, because if I don't believe in this, I'm basically wasting my time, all of us. And there are people who are actually in position of power, position of giving justice out, believe in these too. And I've witnessed it in attending hearings, etc., and International Criminal Court. Judges have questioned the prosecutor and their actions and their attitudes and even their words. You know, how dare you say things like this? As if they're defending the perpetrator of the crime. And so it gives you hope. ICC judges have not basically yielded to the American threats. The state minister, American Secretary of State or National Security Advisor or whoever threatens the judges directly or the prosecutor. Despite that, the case is still going on in the International Criminal Court. It gives me hope. And it also gives me hope the fact that they are scared of what's going to happen to them for what they did in Afghanistan. This is not going to go away. It's the reason why they're trying to tackle politically the International Criminal Court and threaten the court and anybody basically who tries with them. But there will be those souls that will seek justice on behalf of the victims in Afghanistan. ICC has the jurisdiction. Whether they try to dismiss it, belittle it, discredit it, these are just words. They're not the law. The law is written. It's there to be practiced, to be implemented, and somebody will. I hope that it's us. I would love to, but somebody will. And that's what they're scared, that they will be held accountable in a criminal court as a state. And their agents, the soldiers, CIA, whoever was torturing, killing, raping innocent civilians in Afghanistan. They will be held accountable. It's what scares them. It's what scares Israel, which is what I was trying to say earlier. The concept of it scares them.
Hakan, how can they be aid of the ICC and of prosecution at the ICC if they are not party to the Rome Statute. Neither the United States nor Israel are party. So
is Syria, my sister. Syria is not party to it, but we have an ongoing application in International Criminal Court. We've actually taken Assad, his brother, his generals, those who actually run the prisons where they rape, kill people. We named them in our indictment, International Criminal Court, against Syria, even though Syria is not party to the International Criminal Court. How you do it? Well, there are ways and means. For example, Bangladesh and Rohingya issue is one. Bangladesh is a member of International Criminal Court. Rohingya people, what they've suffered is spilled over, and ICC prosecutor basically invited applications, which allows any spillover effect to be judiciary correct path to make the application. So there are ways you find that you can actually apply. In Syria case, that's what we did. We just have to think new. We have to be innovative. If you try to do everything by the book, it's a status quo, then you're not really a good lawyer. The good lawyer is you find ways and you actually dig it, you find it. And in Syria case, we did successfully. And now we have over, 2,185 Syrian victims who are actually filing at the prosecutor's office. There will be ways, and you will see, there will be ways where American soldiers will be held accountable. I'll give you, if there was, for example, if I'm an American national or UK national and my relative was killed by American soldiers in Afghanistan, for example, or tortured, I could actually use many different legal avenues to open up a case. And by opening up a case against one, I could actually open up a case against the state that sanctioned the behavior of the individual soldier or the unit or the fighter pilot, etc. And widen my case up. There are ways and means that could be found. And the whole idea is, even though it's a case of one, it's a case of whole. You actually run the case like that. So it's possible. There are ways and means.
Inshallah.
Can I just very briefly make a comment on this? This is Catherine,
Yes.
because I represent victims in the Afghan situation of U.S. torture. And the answer actually on this one is very crystal clear, right in the text of the Rome Statute. When non-nationals of a state party commit a crime on the territory of an ICC state party, if the crime is of sufficient gravity and otherwise falls within the jurisdiction of the court, they can be brought before the ICC. American citizens operating on 123 countries, which are part of the ICC, those Americans in Afghanistan, they knew that they could be brought before the ICC. So it's very clear. And when it comes to the U.S. interference with the independence of the ICC, whether the judges or the prosecutor, we have filed a complaint with the UN Special Rapporteur on the independence of judges and lawyers because this pressure campaign, these threats being made against the court are truly interference with the independence of the judiciary. This is something that you see from dictatorships and authoritarian governments. This is not something that we should be seeing from the administration of the United States.
Thank you very much, Catherine. The next questions go to Yusha. What can be done to stop large South African corporations and citizens from supporting Israel financially as the Jewish Board of Deputies and their members? And the second question, is there a move towards establishing a pan-African legal front for cases against Israel apartheid? This is a question coming from a colleague in Kenya. I think, yes, Yusha, if you could please address those two questions.
Yeah, so in essence, at the moment, in regard to a pan-African attempt, I'm not sure. I mean, I don't know if other colleagues on the platform know if there are any moves to do so. We did approached the African Union with the complaint, and all we've had for 5 years is an acknowledgement of receipt. So we've not had any assistance from the African Union Secretariat in the Gambia yet, but there's certainly a move to try and get some sort of African prosecuting authority to deal both with our own and hopefully to deal with so-called non-African perpetrators of war crimes and crimes against humanity. But that, I think that's a long way ahead. We've had the sitting of the Pan-African Parliament in Midrand on a few occasions. We've delivered complaints to this institution, but it seems to be that the same virus that affects the ICC affects this institution as well, because they're just sitting on an acknowledgement of receipt, and unfortunately we've seen no action on it. Insofar as the funding of Israeli institutions are concerned, yes, there's certainly legislation that we can utilize currently, and I think the BDS movement referred to by Ziad earlier is certainly taking up the campaign to isolate these institutions, identify them, and then hold them to account for funds that they are utilizing. But the difficulty we've always had with the Jewish South Africans is that tracing the route has become extremely difficult. That they utilize, and I know that there are other organizations in Cape Town utilizing this. There's certainly evidence of 2 individuals that I know of that are currently serving in the IDF, which have not yet come to the fore, and I'm hoping that that does come to the fore. But certainly in regard to funding, there's legislation and there's the provisions of the Foreign Military Assistance Act that we can utilize to stop and prosecute if necessary. The difficulty in all of these things, unfortunately for me, there was a certain degree of sarcasm that I used in my initial address, is that we just don't seem to have the political will in this country to move. So, just looking at the questions is, although we've downgraded our relations with Israel, with our noble history of fighting and resisting apartheid and all of those good things, we just don't seem to have the political will. We terminate or downgrade an embassy, yet we maintain full financial, economic relations with Israel. So it just doesn't make sense. It's kind of like the science and medicine around the COVID-19 virus. It's just none of it is making sense whatsoever. So you say on the one hand we'll terminate diplomatic relations, but Israeli ships are sitting at our ports, and COSATU has to be mobilized to stop offloading them. But why are they coming here in the first place? So there's a lot of difficulty with our government at the moment, and the prosecutors, as Hakan has indicated, local prosecutors are making it difficult. So the Jewish lobby has long and very dirty tentacles all over the place.
Thank you, Yusha. I think that what is required is a very strong lobby, not just in South Africa, but across the board. And that's where the Israeli lobbyists have been very, very potent in working in the USA, in working against any prosecution at the ICC and in other places. We've seen how widely spread their tentacles have reached into Africa as well. And it's up to us, solidarity activists, lawfare activists, all minds, all people who support the Palestinian cause, to try and continue to lobby our governments and apply that kind of pressure so that the correct decisions are taken, not just superficial decisions like the downgrade of the embassy. I have some comments and questions from Dr. Junaid Ahmed, who says, perhaps a reiteration of an earlier allusion to international law and the legal terrain in general. While I certainly believe that both the work our panelists are doing to raise crucial awareness to broad swathes of populations who don't know the extent of Zionist criminality, but there is a question that haunts us. Since not only the birth of Israel, but since the Balfour Declaration, since we have Zionists paid any attention to any sense of legality and being supported by one empire to the next, it has never cared about the gazillion international humanitarian laws it's violated, as well as the UN resolutions. The Americans have threatened the families of ICC judges if they prosecute American war criminals, and I'm sure the Zionist entity shares the same attitude. He goes on to say, the conditions of the Palestinians is an abysmal state after laws have been ignored by the Zionists. It seems like what really shook the Israelis was when Hezbollah humiliated them in 2006. In brief, does it seem like that the panelists' important legal work should also emphasize a serious political and geopolitical struggle against the Zionist state if we want to see an amelioration of the desperate conditions of Palestinians? Dr. Junaid also goes on to thank us for brilliant presentations. I think in tandem with Dr. Junaid's comments and questions, there is one more from John Philpott, who says, can we not explain the slow progress at the ICC by the fact that Fatou Bennouda and the prosecutors, pardon me, I'm losing sight of that question. If you would just give me a moment to be able to read it on my other device. That the prosecutor's office has historically been pro-USA, and we know that there is some progress now. Hakan, would you like to address those questions?
I didn't hear the last line that you read. What was his question?
The last line was from John Philpott, speaking about the prosecutor at the ICC historically being pro-USA, and how that might affect the progress.
We obviously respect his opinion of the prosecutor. To say that she is pro-US would be, this is not how we interpret the behavior. How we do things is in a different way. You look at the actions of the prosecutor. She has basically completely ignored the legal rights of victims that we represent and many other. You can tell she played it safe. You could say this easily because she did. She only has just over a year in her post, and she's probably already making her plans post being a prosecutor of the ICC. It's a career decision. So she has not been taking the risks, if you like. In saying that, she recommended that the US to be held accountable for what it did in Afghanistan. When it comes to Israel, however, she basically did nothing at all. Not a single step forward or progress. And the Madam Prosecutor has been completely ineffective. She has the authority, and she has the law, and she has the platform, which is the whole purpose of the ICC. Overall, what I fear is we have one international institution that's out there that people like our victims, our clients can go to seek remedy. And they're killing the legitimacy of it by inaction, either the prosecutors or the court itself. It's not practicing what's been designed and established for. And that's what makes it really a sad story. I mean, if we do not have a court that actually has a legitimacy in the eyes of those who apply to it, etc., then we have nothing. And that's what scares me the most, because the Rome Statute itself is a beautiful document if it could be implemented, but the court that has been mandated to actually implement the Rome Statute is ineffective, and that's what makes it really bad. And this prosecutor, Fatou Bennouda, has not helped by having such a hands-off approach to all of the most of the applications. The only success story they keep talking about is one or two African leaders that actually at one time when they were in government actually did things. And that's why you can understand the resentment in African countries about this particular court and this particular prosecutor going after one or two African dictators, and that's it, nothing else. But that's not what ICC is all about. Come on. And that's why I understand the frustration and the comment made by Mr. Philpott.
Thank you so much, Hakan. Our last one is a comment rather than a question that suggests to our panelists and to some of the legal representatives, someone should file a request for information about the Israeli attack on the USS Liberty in '67. With that as the last point, I would like to express my deep thanks to all of our panelists and also to the people behind the scenes, part of the Freedom Flotilla Coalition, Anne, David, Shabnam, Jace, and of course to the Palestine Solidarity Alliance in South Africa, Nazim, and the entire team. I really appreciate the fact that you've all made time for this webinar, and I think that it has been really impactful. I appreciate all of our listeners joining us, and this will be shared and the documents will be made available as well. Thank you for your time and good night.